Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. Today, I am going to discuss my 20th lecture, that is medical negligence and human rights issues. Medical negligence and human rights issues, I have chosen this topic so that I can explain you the human right aspect of medical negligence, where medical professionals, they are negligent in performing their legal duty. So, what is law on that? And if due to their negligence, if a patient who has lost his life, then what would be the legal consequences for that medical professionals? Many times you might have seen that through newspaper or media, that a surgeon during his surgery left cotton in the abdomen of the patient, and after 2 months, 6 months, due to chronic pain when he took advice, then it was found that a cotton was left in the abdomen of that patient due to negligence. At the time of surgery, doctor knowingly or unknowingly he left cotton in the abdomen of patient, due to which many times you might have seen that a patient dies. So, what would be the legal consequences of that? As you might be knowing that every person has right to live with human dignity. A right to life is a fundamental right under Article 21 of the Indian Constitution. As per Universal Declaration of Human Rights 1948, every human being has right to live with human dignity, and this right is guaranteed under Article 3 of the UDHR. Article 3 of Universal Declaration of Human Rights says that every human being has right to live with human dignity irrespective of his caste, creed and religion. Our constitution makers, they have recognized that precious right under Article 21 of the Indian Constitution, where a person who is suffering from a disease, particular disease, has gone to the hospital seeking advice, medical advice from a doctor, and there he loses his life. If patient dies due to negligence of a doctor, then the question is whether that doctor should be held responsible for the death of the patient. Law says that, you all may be aware about section 304A of the Indian Penal Code, which says that causing death by negligent act is an offence. Section 30A of the Indian Penal Code makes an act as an offence. Causing death by negligent act is an offence. So, there is no doubt at all that where death is caused by negligent act, even a doctor, then doctor should be held responsible for medical negligence under section 304A of the Indian Penal Code. So, medical negligence here means negligence by medical professional. The word negligence here means breach of positive duty, breach of legal duty. Negligence here means omission, failure to perform legal duty imposed by the law. So, negligence literally means omission, failure to perform legal duty imposed by the law. Breach of legal duty is a negligence. Simply you can say that breach of legal duty is negligence. And if duty is breached, that legal duty is breached by medical professional, that will be considered as case of medical negligence. Law has imposed legal duty upon medical professionals to perform their medical activities in accordance with the law. For example, if a homeopathy doctor is performing allopathic medicine, then it would be a breach of legal duty, because a homeopathic doctor is not allowed to intervene into the domain of another medical professional, because homeopathic doctor was given license by Indian Council of Homeopath to perform homeopathy. So, that doctor is supposed to have expertise in homeopathy, not in allopath. So, obviously, if he performs homeopathic doctor, if he performs allopath medicine, it may be injurious for the health of that patient, and if patient dies due to supply, due to overdose of allopathic medicine by that homeopathic doctor or by that Ayurvedic doctor, it would be a breach of legal duty, and that doctor, homeopathic doctor, may be covered under that act. He may also be prosecuted and convicted for causing death by negligent act, because he is not supposed to intervene, he is not supposed to perform allopathic medicine, because that is totally separate branch. Similarly, a allopathic doctor is not supposed to perform homeopathic medicine, he is not supposed, because he has expertise in allopathic medicine. So, the problem with our system is, many times you might have seen that in remote areas, in remote villages, even today doctors, homeopath doctors, they do not have adequate degree, but in spite of that they are indulged in malpractices, they are indulged in such kind of activities, and that is why cases pertaining to medical negligence are reported in newspaper and media. So, I have chosen this topic so that I can give you entire information regarding medical negligence and human right issues. So, let us understand this concept medical negligence and human right issues with the help of these slides which I have prepared. Now, you can see on your screen that I have chosen this article 3 of UDHR. Every person has a right to live with human dignity. I have just discussed this. Article 21 of the Indian Constitution guarantees right to life as a fundamental right. This right to medical aid as a fundamental right under Article 21 of the Indian Constitution. Every person is entitled to get medical aid under Article 21. Now, liability for medical negligence, as I said, negligence by medical professional is a medical negligence, where medical professionals, they have failed to perform duty, desired statutory duty, it would be a case of medical negligence. Now, liability for medical negligence may arise in both the cases, civil liability or criminal liability. So, where medical negligence occurs, happens, that victim has two options. He or she has right to get compensation from that doctor who is negligent, who negligently performed that activity, right to get compensation, and in criminal liability you can also, the patient who has lost his any organ of his body, he can also file a complaint for what? Are the dependent of the patient causing death by negligent act, section 304 IPC. I have chosen this. Causing hurt or grievous hurt or miscarriage, you means victim has right to lodge a complaint, file a complaint for causing hurt or grievous hurt or miscarriage to the patient. So, even you see victim has two options. First is that patient has right to get compensation from the doctor who has been negligent, who has negligently performed that case. If there is sufficient evidence, if patient has succeeded in establishing the fact against the doctor, definitely law would assist him. Definitely law will provide adequate compensation to the patient. If compensation is not adequate, then patient may again come to the high court for adequate compensation. So, this is another remedy in the hands of patient. Second important remedy in the hands of patient is patient or the relatives of the patient, dependents of the patient, they can lodge FIR or complaint against the doctor. Doctor who has breached the law, who was negligent at the time of performing the surgery. So, complaint may also be filed. If that doctor has caused death, causing death by negligent act, section 304, a complaint may be filed under section 304A of the Indian Penal Code. If hurt or grievous hurt is caused by a doctor, by medical professional, then he can also be, then the doctor can also be prosecuted and convicted for causing hurt or grievous hurt or miscarriage. In case of miscarriage, he can also be, doctor can also be prosecuted and convicted. You see, law will not make any difference between government doctor and private doctor. Both government doctors as well as private doctor, both are responsible for their medical negligence. One thing which you need to understand. The second important thing is that you all might be knowing one Latin maxim which I just want to explain you. With the help of that Latin maxim, the liability of doctors, medical professionals in case of civil or criminal law, you can understand that in better way. So, for that reason I just want to mention a Latin maxim on this liability for medical negligence. You might be knowing that Q facit per alium facit per se, Q facit per alium facit per se. This is Latin maxim. The literal meaning of this Latin maxim is one who acts on behalf of another acts himself. Meaning thereby this concept is known as vicarious liability, you just vicarious liability, where in tort, that is also tortious liability. You might have heard in tortious liability that any wrong which is committed by a servant during course of employment. So, wrong committed by a servant during course of employment, his master can be held responsible for that. In case of partnership, where one partner has committed any fraud, any wrong, the entire member of that firm partnership can be held responsible for the wrong committed by one partner. So, that is the concept of vicarious liability, Q facit per alium facit per se. The same concept is available, the same principle is applicable for the government doctors, where government doctors have committed any medical negligence, state would be held responsible for that. You need to remember this thing. Why? Because that medical doctor, that government doctor was acting on behalf of the government. So, government would be held responsible even that patient has right to get compensation against the state. This is where doctor who has committed medical negligence is working in a private nursing home, he has his own private nursing home, even nonetheless he would be held responsible for the wrong committed by that negligence committed by that private medical doctor. The point which I wanted to highlight is, in case of medical negligence that is committed by a government doctor, government would be held responsible for that. Let us understand this with the help of illustration. A doctor who is employed working at primary health center, CHS, community health center, he is a government doctor. If he has committed any medical negligence, then that victim, that patient has right to file a suit against the state, and the state would be held responsible for that. State may be directed that this much amount, whatever loss or injury patient has suffered due to medical negligence, state concerned may be directed to provide that much amount, the amount of compensation to the patient. This is one aspect of medical negligence, vicarious liability. You might have seen that a doctor who was operating surgery and unknowingly, mistakenly, negligently he operated another part of the body. Patient was admitted in hospital, he was to be operated, the patient was to be operated by that doctor. He was suffering from spleen, if he had, patient has any spleen problem, or if patient has any stone in his stomach, but doctor operated any vital part of another part of his body negligently. Once the negligence is established before the court, that doctor would be held responsible for that. So, this is a case of medical negligence. So, you might have some problem that I have highlighted medical negligence, whether doctors are not protected in law, whether doctors have any protection in law. So, they are protected. Law also provides absolute immunity to the doctors, so that they can perform their medical activities independently, transparently, without fear and favor. How law is helpful for them? I just want to highlight those statutory provision where medical professionals, they have more liberty to perform their activity, medical activities more independently, transparently, without fear and favor. Those statutory provisions are section 92, 93 of the Indian Penal Code. That Indian Penal Code gives liberty to the medical practitioner, which I just want to explain those statutory provisions with the help of this slide. I have chosen this slide. You see, exemption from criminal liability. What kind of exemption has been given to the doctors, medical practitioner in Indian Penal Code from criminal liability? No medical practitioner, no doctor would be held liable for breach of law. No doctor would be held liable criminally. Criminal liability cannot be imposed upon the doctors. Two important provisions, section 92 of the Indian Penal Code, IPC, I have referred this. Section 93 of the IPC, section 93 Indian Penal Code. Section 92, 93 of the Indian Penal Code, I just want to explain this. Section 92 IPC says that nothing is an offence which is done without consent in order to save life of the deceased. This is very important. And communication given by a doctor in good faith, it is also protected. You can understand this with the help of example. Section 92, I have chosen this slide so that I can explain you the law regarding protection, means protection provided to the medical professionals. 92 IPC Indian Penal Code says that nothing is an offence which is done by a person without consent in order to save the life of that person. So, that act is absolutely protected, exempted from criminal liability. You can understand this with the help of example. Suppose a person who has had injury in accident, in a motor accident, he is admitted in a hospital, and that patient is not in position to give his consent to the doctor. You all have idea that no doctor will operate a patient without giving consent on behalf of the guardian of the patient. You have to fulfill that form, consent form, that I have no objection if my patient is admitted in this hospital and if doctor has decided to operate him, because that act is necessary to save the life of my patient. So, I have given this consent to this doctor. Without that consent letter, doctor will not start that operation surgery. So, suppose a person who is suffering from brain injury is not in position to give his consent, and there is no relative, neither father nor brother is present in the hospital, then what doctor should do? Doctor has two options. Either that doctor may refuse to admit that patient, that without fulfilling this consent letter, I will not operate this case. This is the first option. Second option is the doctor on humanitarian ground, in order to save the life of that patient, has decided to start brain surgery without consent of the patient, and he has a 20, I am just explaining, giving you example. He has 20 years experience, and for the last 20 years no patient died during that operation, but at this time the doctor could not save the life of that patient. Can you imagine that the relatives of the deceased patient has liberty to lodge FIR against the doctor? They can say before the court that doctor should have waited, should have obtained the consent from the relatives of the patient. Doctor should be held responsible for the death of the patient. Doctor, in this case, in this illustration which I have just referred, the doctor is absolutely exempted from criminal liability. No relatives of the deceased can lodge FIR against the doctor. Under Indian Penal Code, section 92 of the Indian Penal Code gives absolute immunity to that doctor, so that he can perform his medical duty, medical activity. So, this is a kind of protection given to the doctor. This is one aspect. Second important provision which always assist medical professional doctors, that is section 93. It is specifically mentioned in 93 of the Indian Penal Code that nothing is an offence when a communication is given in a good faith. Good faith here means due care and caution. Suppose a person who is suffering from incurable cancer and doctor has inquired that there is no relative of the patient who has come in the hospital. So, doctor has communicated, suppose if doctor who communicates the patient that you will not survive for more than 2 months, 3 months, because you are suffering from chronic cancer, acute cancer, and this type of cancer is incurable in medical science. After hearing that advice, the patient dies. Can you imagine that doctor should be hanged? Can you imagine that doctor should be punished for giving that information to the patient? That information is absolutely exempted from criminal liability. Doctor is absolute exempted from criminal liability. No legal action can be taken against the doctor for giving this kind of communication to the patient. So, you must remember these two important protections which are available to the doctors. It does not mean that they are above the law, doctors are not above the law. The point which I wanted to make here is they have liberty to perform their medical activities independently, fearlessly. These important statutory provisions are just like a sword, just like a effective weapon which they can use for the defense. But if they have committed negligence, they have breached the law, they have failed to perform duty as per the statutory requirement, obviously they would be held liable for medical negligence. With the help of judicial pronouncement, I would like to highlight the cases of medical negligence and how doctors have been held responsible for medical negligence, and patient, victim, dependent of the patient, they have got compensation against the doctors in case of medical negligence. So, you just see on your screen, this is another slide which I have chosen, so that you can get entire information. This is a Latin maxim, voluntae non fit injuria. You all might be aware about this Latin maxim, voluntae non fit injuria. Where there is consent, there is no injury. Where surgery is conducted by a surgeon with due care and caution, is absolutely immune from criminal liability. Few minutes before, I just discussed two important statutory provisions where doctors are absolutely immune from criminal liability. Where operation or surgery is conducted by a surgeon without consent of the patient, even though he is absolutely exempted from any kind of criminal liability, section 92, 93. Now, I am talking about that aspect where a surgery is conducted by a surgeon with the consent of the patient or the relatives of the patient. Where surgery is conducted by a surgeon with the consent of the patient or the relatives of the patient, that doctor would not be held liable for any kind of mishappening unless provided that doctor was negligent at the time of doing the act. If doctor was negligent at the time of surgery, only then he can be held liable for medical negligence. Otherwise, if that surgeon has taken due care and caution, all precautions, safety measures, and has conducted surgery, but he could not save the life of the patient, he is absolutely safe. Doctor is absolutely safe. No legal action can be taken against the doctor. If there is a video recording, if there is a recording of that operation, and if matter is brought into the notice of the court, court may call the CD, the video recording of that operation, and with the help of medical board, if court reached on conclusion that the surgeon at the time of conducting that surgery has taken all the safety measures, took all the precautions, but in spite of that he could not save the life of patient. That is, he is not at the fault, that surgeon is not at the fault, he should not be held responsible for that, because he was not negligent. So, here in this case where surgery is conducted with the consent of the patient, doctor is exempted from criminal liability or from any liability. So, you see, I have referred three important situations where medical professionals are absolutely exempted from any kind of liability. The first is section 92, second is section 93 of the Indian Penal Code, and third situation is where surgery is conducted by a surgeon with the consent of the patient, section 89 of the Indian Penal Code. You see, you must remember all this. My humble suggestion to all the students is that you all must remember three important provision of the Constitution, three important provision of the Indian Penal Code IPC, section 87, section 88, section 92, section 93, because in these four provisions the rule regarding consent is given. Voluntary not fit injuria, where there is consent there is no injury. So, you all must remember section 87, 88, section 92, 93 of the Indian Penal Code. So, you all need to remember two things: doctors, medical professionals, they have got absolute protection, immunity, against whom no criminal case can be initiated, no civil liability can be fixed if they have performed their duties with utmost care, with due care and caution. Otherwise, if they are negligent, they have not conducted their medical activity properly, they would be held 100%, they would be held responsible for their medical negligence, and they may also be punished. Imprisonment may also be awarded to that medical practitioner, to that doctor who was negligent at the time of surgery. With the help of some leading cases, I will try to explain this concept. Now, you just see on your screen types of medical negligence. You might have seen that medical negligence may appear in different forms. Misdiagnosis, where radiologist, I will explain one by one. Surgical error, where surgeon has committed error. Failure to obtain consent, doctor has not obtained consent. Anesthesia error, and these are governed by one Latin maxim, res ipsa loquitur. In medical negligence, res ipsa loquitur means things speaks itself. So, this is the literal meaning of res ipsa loquitur, things speaks itself. So, now I would like to explain this. Medical negligence may occur in form of misdiagnosis. Pathologist, you see MD pathology, a doctor who is having degree MD in pathology, MD, he is a MD pathology. If suppose if pathologist has prepared a wrong report, it would be a misdiagnosis. If on the basis of that pathology report, a person who is not suffering from a particular disease and doctor has conducted, physician has advised him to take medicine, and if that medicine has caused any harm or injury to the patient, then that pathologist would be responsible for that. If suppose a radiologist, a doctor who is having degree MD in radiology, if that X-ray report is, CT scan report is prepared by on the basis of recommendation made by that MD radiologist, then MD radiologist would be held responsible for manipulating, fabricating, for giving false information in that report. Though a person was not having, a person who is having chest pain, for that he has conducted a X-ray or CT scan. In that CT scan, it reveals that radiologist has stated that he is suffering from tuberculosis, TB. So, and in fact, there is no tuberculosis to that patient, and medicine is supplied. 6 month, 8 month course is he is allocated 6 or 8 months, that he is advised by doctor to take medicine for 6 or 8 months. It would be wrong diagnosis, and for that wrong diagnosis, the medical practitioner, medical professional would be held for medical negligence. Surgical error I have already highlighted in detail. So, if surgery is not conducted properly, then surgeon would be held responsible. Failure to obtain consent, where doctor who has failed to obtain consent, and without consent, if this thing is very safe when doctor has conducted surgery in order to save the life of the patient. So, in that situation, consent would be immaterial. Whether consent has been obtained or not, it would be immaterial if the purpose of surgery is to save the life of the patient, and he has conducted surgery with due care and caution, then he can't be prosecuted. Anesthesia error, many times you might have seen that due to anesthesia problem, due to poor anesthesia, the patient cannot survive in a hospital, or patient dies. So, in that case, if it is proved before the court that due to the negligence of anesthesia, that operation was not successful, in that case a person who is having degree in, a doctor who was called as just to give anesthesia, so that doctor would be held responsible for that anesthesia error. And these are the cases of medical negligence, and medical negligence may appear in these different forms. But the most of the times we find in newspaper or in media report that due to surgery, due to surgeon, due to wrong malpractices, negligent surgery, patient dies. So, in that case, surgeon who has been negligent cannot be protected by law, and definitely he would get punishment. Penalty may also be imposed. We come to that aspect, penalty aspect. Now, come to this slide. You look on your screen. I have chosen this topic, role of Supreme Court in prevention of medical negligence. How Supreme Court has been effective in preventing medical negligence. I have chosen two important case laws, Poonam Verma versus Ashwini Patel, EIR 1996 Supreme Court, Jacob Matthew versus State of Punjab, EIR 2005 Supreme Court. So, I would like to discuss the first case, Poonam Verma case, Poonam Verma versus Ashwini Patel. What actually happened in this case, Poonam Verma versus Ashwini Patel case? Poonam Verma, petitioner, the wife of the deceased, she had lost her husband due to medical negligence of Dr. Ashwini Patel. Dr. Ashwini Patel was a homeopath doctor, and the husband of Poonam Verma had stomach ache, had some problem in his stomach, and he went to take advice from Dr. Ashwini Patel. Ashwani Patel, being a homeopathy doctor, he is advised to take allopathic medicine. Dr. Ashwani Patel, who was a homeopathy doctor, gave heavy dose of allopath medicine to the husband of Poonam Verma. As a result of that, he was admitted in a hospital. When he was admitted in hospital, doctor, they found, when pathology test was conducted, pathology report revealed that due to heavy dose of allopath medicine, his intestine was affected, and due to which patient died. Then Poonam Verma, she obtained the report, pathology report, medical report from that hospital, and she filed a case complaint against Dr. Ashwani Patel. When matter was brought into the notice of court, High Court, you see, Poonam, the wife of deceased Poonam Verma, she mustered a courage to fight that battle because she had lost her husband, and she went in appeal in Supreme Court. When matter was brought into the notice of Supreme Court beautifully made a clear-cut distinction between allopathic medicine and homeopathic medicine. In this case, Supreme Court said that Dr. Ashwani Patel was negligent in performing his medical profession. He was held responsible. Supreme Court held that Dr. Ashwani Patel, having homeopathy degree, he intervened into the domain of allopathic medicine, which he was not supposed to intervene, into the domain of allopathic medicine. Neither he was allowed by the medical council ethically, not legally. So, it is a case of medical negligence, and Dr. Ashwani Patel was compelled to provide compensation to Poonam Verma, deceased wife. In this way, you see, how Supreme Court held that in case of death of patient, the doctor concerned would be held liable for causing death by negligent act. Section 304A of the Indian Penal Code, which talks about causing death by negligent act, is an offence, and Dr. Ashwani Patel was awarded punishment under that section. Supreme Court further held that doctor should be, his license should be cancelled. He should not be, his license under homeopathic. So, medical council is also directed to cancel his license, so that he should not continue his practice. This is another important effective measure which Supreme Court adopted in this case, that such kind of people, such kind of doctors should be debarred from performing their medical professional, and their license should be cancelled. So, medical council was also advised by the Supreme Court, directed by the Supreme Court, to cancel his license, so that he cannot repeat such kind of incident in coming future. So, you see, this is all about one important case, Poonam Verma versus Ashwani Patel. So, I think that you all have understood the fact of this case. Second case is Jacob Matthew, and now come to another aspect. I have chosen this slide, that is statutory protection to victim of medical negligence. What are the statutes, and under which statutes victim of medical negligence are protected? I have chosen this one act, the Consumer Protection Act 1986. First thing is lack of service. I will explain how lack of service is treated as important ground to take relief under this act. Second is medical doctor patient relationship. Patient has right to file a complaint. Third, there is an important case on this, Bolam versus this Foreign Hospital Management Committee, I 1957 Supreme Court. In this case, what Supreme Court has established that Bolam test, this is a very important case on this point. Bolam test is very important on medical negligence. According to this test, where treatment is provided with due care and caution, medical professionals would not be liable. This is one important. So, now let us discuss Consumer Protection Act 1986, lack of service, doctor patient relationship, and then after Bolam case. You see how Indian Parliament has enacted a special legislation in 1986, the Consumer Protection Act 1986. Doctor patient relationship is just like consumer and consumer relationship, and doctor, once medical fee is submitted, medical fee is paid by a patient to a doctor, whether doctor is a government doctor or private, it is immaterial. The moment medical fee is given by a patient to a doctor, at that very moment patient doctor legal relationship is established. Doctor is supposed to provide better or best medical services to the patient. If after obtaining medical fee from the patient, if doctor has failed to provide best medical treatment to the patient, it would be a case of medical negligence, it would be a case of lack of services. Because in under Consumer Protection Act, if you are a consumer, if you have paid money for services and the service provider has failed to provide services after having that much amount which he was supposed to provide service, if he has failed to provide that service at that level, then it would be a case of breach of law, it would be a case of that consumer has right to file a case against that service provider. The same case is with doctor and patient relationship. If patient has given fee to the doctor and doctor has failed to provide his services, medical services to the patient, it would be a case of lack of service. If there is any breach of law, if that doctor is has committed any omission, has failure to provide, then he would be held liable for medical negligence. You must remember this thing. This is the sole basis, lack of service. If you are providing money, if you are paying fee for the services, for good services, and if good services is not provided to you, then you can file a suit against that service provider, that doctor. So, this thing which you need to remember. But what happened in this Bolam case, Supreme Court for the first time laid down various guidelines in order to protect medical professionals as well as protect the rights of patient under this case. Supreme Court laid down various guidelines in this Bolam case and held that where any nursing home, where any hospital, be it government hospital or a private hospital, has taken all the safety measures, due care and caution, and provided medical services to the patient after taking due care and caution, then no doctor would be held responsible for medical negligence. The point is, it does not mean that doctors, medical professionals, they are absolutely immune. They can be prosecuted and convicted. The point, you see, this guideline is very clear: due care and caution, good faith, section 52 IPC. If doctor who has not taken due care and caution at the time of performing the surgery, so obviously he was negligent. And if patient or relatives of the patient, they are in position to establish this fact before the court of law, obviously the doctor would be held responsible for that. On the other hand, if medical professional, if they are in position to prove before the court that they had taken all the measures, precautions at the time of surgery, they had taken due care and caution at the time of performing that surgery, then the moment they prove the fact before the court, they can't be held responsible for that. So, in the light of these two statements, you will have to, if medical professional has taken due care and caution, then he would not be liable. If due care and caution is missing, then obviously the doctor would be held liable for medical negligence. So, I think you all have leading case on this point, that is, I have chosen two important cases. You see, the first case is Indian Medical Association versus P. Shanta, AIR 1996, and Shamira Kohli versus Prabha Manchanda 2008 SCC. Indian Medical Association versus VP Shanta versus AIR 1996. What happened in this case? Supreme Court held that failure to obtain informed consent from patient would be treated as negligent act. Where Supreme Court held that where doctor has failed to obtain consent from the patient and patient was not in position, patient was unconscious, he was not in position to give his consent and consent is not obtained by doctor, then doctor would be liable for that, medical negligence. In this case, Samira Kohli case, Supreme Court held that a hospital can be held liable for negligence of its employees even if hospital itself was not directly at fault. So, you see, Supreme Court has widened the scope of medical negligence in this case, Samira Kohli case. Supreme Court held that hospital can be held liable for the negligence of its employees even if the hospital itself was not directly at fault. If doctor is at fault, has committed any medical negligence, hospital cannot escape from its liability. So, that hospital would be liable for that, that nursing home or hospital would be compelled to provide compensation to the patient. So, that hospital cannot say that it was not at fault, it is the fault of doctor. So, this case is also very important in order to provide justice, in order to provide compensation to the patient. Now, so I think I have covered each and every aspect of medical negligence, right from Latin maxim voluntae non fit injuria, right from the provision of Indian Penal Code section 92-93, which gives immunity liberty to the doctors. They cannot be prosecuted, they cannot be convicted if they have done their job, if they have done their medical job in accordance with statutory provisions, if they have given communication in good faith, they can't be liable. If they have conducted surgery in order to save the life of the patient with due care and caution, the moment negligence is not proved before the court, doctor cannot be held liable for that. I have covered each and every aspect of medical negligence and human rights issues provided in UDHR. So that you can get entire information relating to medical negligence, how state can be held responsible for a medical negligence committed by its doctor, how a private nursing home, private hospitals can be held responsible for that, how where a homeopath medical doctor who intervenes into the domain of allopathic, how he can be held liable for that. So, I have covered each and every aspect of medical negligence, assuming that you all have understood the case which I have just discussed. If you remember all these things, definitely I do believe that you will get success whenever you write all these things in your any examination. So, with this I would like to conclude my lecture. Thank you all.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that is the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally you try to combine all of them to say that what are the guiding principles in life. Then you say you are looking at life, you are looking at humanity from a pure philosophical point of view. And this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.